everyone, this is Archana here. Welcome to another podcast with me. Today we will be talking about IPR, copyrights, disclaimers, legalities towards holding a website, blogs, and much more. Today the entire world has been blogging, is on Twitter, is on Facebook, is on LinkedIn. People have come up with mobile apps, they have come up with so many websites. Let's find out what are the things that need to be taken care of to safeguard ourselves from all legal complications. Today I have with me Mr. Sanjib Mohanty and Mr. Pankaj Singh. They both are Supreme Court lawyers and a part of my professional network. They are representing their company, the Shebang, based in Delhi. With their offices in Delhi and Mumbai, they have both national and international clients. They have expertise in IPR, and let's hear it out from them what they have in store for us. Hello Pankaj ji, hello Sanjeev ji, welcome on board.
Hello, Archana. How are you?
Hello.
Great. We are so very happy and glad to have both of you today. So we will take this question forward. Today, Pankaj, this question is for you. So people today are making a lot of mobile apps, because we know that during the COVID-19, the movements of the people have been restricted. And a lot of people from different industries have made their mobile apps for different services they're offering so that they could reach out to people and ease off, supply chain management or distribution of their services or making their services available. So people have launched these apps. What are the legal things that they need to keep in mind while launching these apps so that their interests are safeguarded?
First one is the copyright, because whatever the content someone uses the services in the app, or everything has to be copyrighted, and the owner of the app is the actual owner of the all those materials, all those services. Now there are many disclaimers, like using the app. For example, I am using the app. Anyone can, and I am the owner. I give a license to any party, to any third party, for any commoners who can use this app. But the owner has a kind of service, grants a service to the third party also, to the consumer also. So the third party can use it for his own beneficial purpose. Right. So basically, the terms and services of any, while we use this app, the owner of the service provider, the app owner, and the third party must have a very sound terms and services agreement that is governed by the Indian Contract Act, with some disclaimers in hand. For example, the disclaimer may protect the owner of the app. For example, anyone can use this as per the policies, because there are policy guidelines that is used, and before registering and before using this app, everyone who registered with this app must go through terms and conditions. Most of the people, they don't read the terms and conditions. And the terms of these terms and conditions are for us, the user, the actual users. So basically, there are some disclaimers which can protect the actual owner. For example, if I use the services and I infringe something, the owner of that app is not responsible, right?
Yeah.
So this saves the owner of that app from many infringements, and the onus is on the user.
Yeah.
So this is one part regarding the disclaimer. I am just giving an example. Then terms, in the terms and services, there is one license agreement, right? So the license agreement gives a license to anyone, to third party, to use the services by whatever means he want to use. In a likewise manner, I have also exclusive right and the license to use the information what the user has provided. For example, the user provides email addresses while registering the app. The user provide the IP address from where he has logged to the actual website. The user provides phone numbers. So now the app owner and whoever launched the app, he also advertently by express agreements get a license to use this information for his own use. But now, what is the use of that information? The use of those information is to have a very good interface between the user and between the app owner, right? The interface uses many kind of things like cookies. Why there are cookies in the website, or why there are cookies in the apps also? Because there are many apps where you will find some suspicious behavior. For example, I am using an app and I am being abusive, right? Or I am holding one services of the app for the long time. So there is a reasonable possibility that I may be using something, I may be abusing. So these are things that are, controlled by the entire algorithm of the app manufacturer or the app controller. So this is one aspect. So these are the information, and also the information is for to know the traffics. How many people are using these apps, and what are the purposes? What are the pages what we are visiting in those apps? So these are different aspects. How the and also the privacy. So when we design an app, we must be having a very robust terms and services agreement with the user, with the third party, in relation to the copyright, in relation to the information, in relation to the very simple contract between the consumer, between the app user, and between the service provider. That includes also data protection and the privacy. One thing I would like to add, that though we have a very, we have a very express contract, but the Indian laws are they don't expressly say much about data protection. This is dealt with GDPR laws, that is General Data Protection Laws. Rights. These are European laws that have come very recently, and the Indian regime, the Indian government or the stakeholders are still are trying their level best to pass it in the parliament, because now there are many instances where our data are being shared with various stakeholders.
So I have one question for Sanjib Ji. Sanjeev ji, we see so many websites today that have come up, especially during COVID-19. There are online platforms for children learning, different educational courses. There are, online cooking courses have started. So many other websites have started. Now, tell me one thing: how can any person who's starting a website safeguard their interest that their, content from the website not be published elsewhere, should not be sold elsewhere, should not be copy and pasted and used on their own sources? So, how can their interest be safeguarded? Can you please throw some light there?
Right. Archana, actually very pertinent question. 3 of my known sources, in fact, they are running a coaching institutes and something for the different domains. So now they are come up with this website, and they are running all the Zoom classes. So when they ask me this very pertinent question, my advice to them, there is something called public domain. Something, because it is a matter of copyright. What you give in a classroom or anything, PowerPoint or anything, suppose a study material printed or whatever discussions going on in the classroom. So it is basically, it's a matter of copyright, audio, video, and the literature, everything. So first thing, in a literature or in a software, in the copyright, author is the first owner of the copyright. Suppose who has prepared the study material, digital, earlier it was handwritten, manuscript and all that. Now this with pen and paper things gone. So it is now anybody doing Control-C, Control-V and doing tinkering and ready. Anything under the sun you write. I can prepare a PhD thesis on any topic within a day. 24 hours it will be ready. So with this technological advent, things are coming too fast. So it is very important that in everything you must first thing you write a C within bracket, or if you put a picture or anything, you must put, that is, if you say, if you are taking a picture from some other sources, it is not everything you creating, but you must acknowledge the source. Good thing is, you supposed to take a permission, but it is not possible. So at least you acknowledge the sources. We have source, like we'll write on a footnote or something. If this is from, if something in a public domain thing, what is public domain? Suppose in copyright we say there is a term of copyright. Suppose in Gitanjali, Shakespeare's thing, anybody can publish because that is already in the public domain. So there is no copyright violation, anybody can take. Suppose you print, also I print, there is no violation. Yeah. But if you make an interpretation of that or something on this poem of the Tagore or something, your notes are there, that is your copy. So what extent is your copyright is what is your original and creative. There should be taste of originality. Originality is there should be originated from a source, and there should call something modicum of creativity. It is not everything. It's like a Shakespeare or Tagore, somebody writing, there will be copyright. Anything. Yeah. A father's letter to daughter is a copyright. If I written a letter, today I was a very interesting thing. Now people are finding in the leisure time handwritten letters. Suppose somebody in the good old days or maybe in 80s, 90s written a handwritten inland letter or envelope, they have written. So suppose there is a things are there, so that is their copyright. It may not be very having a literary value. That's a, that we call that literary. So anything you create must you acknowledge that it is taken from which source. If it is public domain, fine. And second thing, if you put something your own and you mark it, this is a copyrighted, protected. And third thing, copyright registration is not mandatory under the law, but it is advisable and beneficial. It's a proof that you can also register. Anything you create, it must register with the registrar of the copyright.
Great, lovely. I think that is a very important input out there again. See, whenever we are, whenever we are creating websites, we are taking pictures, we are taking content from many places on the Google. So we just have to make sure, because we may or may not be in a position to take permission for using that content or that picture. So we need to acknowledge. Please.
I just want to add something. I like your Facebook page. You have put some picture. If I want to share or I want to cut paste, I will write courtesy Archana's page. So that is, we call fair use, doctrine of fair use. So I am not violating copyright violation because I am acknowledging what is the source.
Pankaj, I would request you to tell us what are those 5 points a person who's making a mobile app to keep in mind so that his interests can be safeguarded. Give us 5 points, please.
I mean, what I can recall, the few points I will say. The first point is the copyright in relation to the content rights and responsibilities. This is the first point. The second point is the license.
Right.
Regarding the post and regarding the license agreement between the service provider and the service provider, that is the app launcher, and the consumers and the users. And the third is the privacy. And privacy in relation to the information that are being collected by the app user, and what kind of information as a consumer what we are giving to the app service provider, right. And the fourth is that, I mean, data security. Yes. What data are secured and what data are not secured. So there is an agreement of data security also. Now there are a few other points. I would say the business transfer. For example, I am having an app and it is being hosted in India, and all the information, and I have your all information in India. Suppose if I shift my business to US, and also I am taking all your information to the US. So there is a business transfer. For example, if I merge with, so this comes under cross-border transfers. Now there is a business transfer also. For example, someone I merge with some company. So shall I share my information to the third party? So there has to be a different terms and services agreement with the other entity that will be formed, either after merger or amalgamations. Now there are others like limitation of liability. What are the liabilities of an app provider? So I would like to have a limited liability. If someone does something, infringes something, or misuse the app, I should not be. I should not
held
be.
responsible.
I should not be held responsibility. Now there are other disclaimers like disclaimers of warranty. If the service, if I'm not satisfied with the service, I cannot ask back for the compensation, right?
Right.
And now there is I was saying that in these agreements, one important what I think is the choice of law. For example, an app is being hosted in the US. I am the user, I am using it in India. If there is a dispute between the service provider and me, where should I go for the, which competent court should I go? So there is an agreement of choice of law. So as a user, I would like to have a jurisdiction in India, but the app or the service provider who is based in the US, obviously for a better, this is called in legal terms of forum shopping or forum convenience. For a better convenience of my law, I would obviously like that dispute should be settled as per the law of the US. So these are some consideration what we must have. I hope this answers your questions.
Lovely, lovely. I think these are very important inputs. Everybody out there who's trying to create a mobile app or has created in the recent past, these are the pointers that you need to keep in mind to safeguard your interest legally. It's not only about India. Even if you have an app which runs internationally, these are the pointers you need to keep in mind. Great, thanks, Pankaj ji. Okay, Sanjib ji, I have the similar kind of a question for you also. Since you have mastery over this, please guide us. I mean, when it comes to website, website, people are launching a lot of different kind of websites. Could be for anything, could be for maybe an e-commerce website, or maybe for an online platform for teaching or cooking or educational. These websites, now when they come into being, what are the 5 points, disclaimers, legal safeguarding themselves legally? What are those pointers that need to be kept in mind?
Already Pankaj has elaborately covered. One thing I want to add, one and two.
Yes.
Domain name. That's when I go for a website, I book a domain name. One has to be very careful. Suppose I take a domain name which is a very well-known name, Tata, Pepsi, Microsoft related. So one has to be knowingly if somebody taking such name, and it should not be taken. So domain name, choosing a domain name is very important. That's the first. Second thing, when you create a website, you know your target. And what Pankaj has said, the limited liability, and you should also take something insurance, indemnify yourself. Suppose there is a court case or something, how you take some insurance or something, third party, so it indemnify. And as far as the IP things are concerned, the content, or if you are using logo, or you are using any other things, like suppose you are doing, suppose these days many things are happening like a affiliate marketing, digital marketing, and you are earning money.
Yes.
Like providing that information or something, referral, you are also earning money. So you should have proper agreement how the revenue will be collected and all that. And in case of a dispute, who will be liable, and whether you are an intermediary, because normally when somebody putting something, you become an intermediary. Something, some puts something religious sentiments or some comments, some writing lewd comments, hurting religious sentiment, obscene pictures, anything, laws of the country. Suppose in US, the privacy law is different. In India, the laws is different. So when the website is accessible from anywhere, any place, So
Absolutely.
there should not be any conflict of law. There should be one governing law, and the place of which court is the competent jurisdiction, because the choice should be with you, so that otherwise you have to go and fight one case in Europe, one in US, suppose you are in India. So that one has to be taken care of.
Yeah. Wonderful. I think this is wonderful information for people to know. And I think, Sanjeev ji, you were also talking about the use of pictures. You know, when we are using pictures, then we either put a, note there that this picture is a source from that website. What is that information you wanted to pass on?
So when you take a picture or anything from any source, you acknowledge the source. If anybody taking, suppose a Taj Mahal picture can be taken by, not by that somebody owning. If I take a picture, my copyright to the extent of my picture. It is not, I monopolize that any picture, suppose nobody can make a copyright. So any picture, any artwork, suppose you are sharing somebody artwork. The artwork is some artist's artwork. So everything anything, it is a visual thing. You are showing it, you are sharing it. So you must acknowledge. If you for something commercial thing, you engage a artist or engage a photographer, take a license from them, because anybody creating that, he is the author, he has the first right. So you take an agreement with them and you use that.
Great. Okay, thank you. Pankaj, you were trying to add something onto this. What were you trying to say?
Yes, I just wanted to add one thing, that if the pictures are taken from the open source, we don't need to worry about that, right?
Okay.
If I take picture, so if the picture itself is a copyright work of someone, a photographer, we need to acknowledge him. Otherwise, there will be infringement. But if the pictures are already in open source, for example, in Google, and any photographs, for the pictures I would use photographs. So if the photographs are in the open source platform like Instagram, and we can share it, we can use it for our own purpose, but we should not make it used for our own commercial gains.
Please, can you please repeat that?
Yes, you cannot use the photographs for your own commercial benefits, and you cannot be a competitive to that actual owner or the photographer, or who is the actual creator of the photos.
Okay, great. I think that is a valuable input from both Sanjeev ji and Pankaj ji. Great. So, we absolutely need to make sure that we acknowledge the person whose picture is being used if that work is already a copyrighted work. We can use, however, the ones which are in the open space available for anyone to make use of it, but certainly cannot commercialize that. Lovely. Okay, great. Pankaj ji, I have another question for you. Today we all are making YouTube channels. I think the entire world today is working on YouTube, giving different kind of content on YouTube. Now, YouTube also, what do you think, and what are the things one person need to keep in mind with respect to YouTube or blogging? Because I see a lot of bloggers have also come into being these days. So what are the things that need to keep in mind? Just give us 5 pointers, please.
Yeah, to explain, like YouTube is also a kind of microblogging. It's an open source platform. Anyone can create YouTube channel and anyone can post the content. The YouTube channel cannot be copyrighted, but the contents of the YouTube can be protected against any kind of infringement. Now there are some points, like there should be a very express disclaimer regarding the authenticity and regarding the accuracy of the information. For example, in YouTube, for example, someone takes a video and posts in the YouTube channel, the platform, someone who is providing the platform in the YouTube channel, he or she has no onus, or he or she has minimum risk regarding the authenticity and regarding the risk, regarding the accuracy of the information or the photographs or the video or the source of the video. So this is a disclaimer that protects the YouTube channel owner. or the holder.
Okay.
The second is again the copyright of the entire content in the YouTube. The third, again, I will talk about the licensing. What this license agreement is between the user and the service provider.
Okay.
The license agreement says that, like for example, a blogger, he or she can use the content to promote the blog or a YouTube channel for advertisement purpose also. And as a blogger or as a if someone is having a YouTube channel, he or she may not sell the content to the third party without the the explicit permission of the author. Now the third is again the privacy. So the privacy is, and it also relates to the YouTube and also to the blog. So there are many informations that are collected by YouTube and the blogs. For example, IP address, phone numbers, emails, location, metadata, and the session activities for security purpose. And there are third-party embedded information also. Like in the blog, somebody may embed a Twitter account. Somebody might embed also the Facebook account. So there is a privacy agreement. What information as a blogger I can take? For example, many of the blogs can take information of your friend list in the Facebook. So what should I do with this Facebook friend list? Should I, and can I share it with the third party? Like giving information to the Facebook, how many Facebook consumers are there in India? So these are the terms and agreement in relation to the privacy. And these information are collected to fight spam and abuses and to generate non-identifying information about how people use the services, and it provides, test, improve, promote, and personalize the services by way of algorithm. And now there is a data security, like I said, the blogger use inscriptions such as HTTPS to protect data transmitted to and from the website. However, no data transmission through the internet is 100% sure, right? So the blogger cannot guarantee the security, or the YouTube channel holder, he cannot guarantee the security to the author regarding the use and the risk. So this should be also considered, and the author should take the reasonable measures to secure their account. Now, business transfer, like we talked before, and cross-border transfer. And there are many miscellaneous provisions like a disclaimer of warranty. For example, if I am not satisfied with the services of YouTube, I cannot claim that I paid for the subscription and I was not able to use the services for that particular period of time, and there were some discrepancies. And there are also limitation of the liability, like for the blogger or YouTube, like for any microblogging. For example, for various kind of damages. For example, if the services are hacked and are not, not available, so as the blogger, I will not be responsible. There is an agreement. There is a very express agreement signed regarding the limitation of the liability, and to end the entire, the measures or the terms and services. Again, the question is regarding choice of law and jurisdiction. So these are the pointers. What this is applicable for all YouTube channel who want to create. To the people who want to create YouTube channels, and this is for all the bloggers and for all the microblogging. For example, someone is using LinkedIn, someone is using Twitter. So this is applicable for all blogging websites.
Great. I think this is a great input. Pankaj, tell me another thing. People are using music. They use they embed music in their blogs or in their YouTubes. And that music may not be composed by them. Could be something available on the internet. So are we supposed to, kind of put a note there that this music has been used from this website, or we can freely use that music? How does it go? Are there any legal complications for using music?
Yes, there is a copyright infringement of the entire music because we are infringing the right of the songwriter. We are infringing the rights of the music composer. So so when we embed this music, we must acknowledge the source. For example, in YouTube channels, many of the songs are used in a different context, but we write a what was the signature, the copyright, and these are the copyright works of Sony Network or for the Sony production. So this prevents a a YouTube channel. Someone who is having a YouTube channel and even the bloggers to protect themselves from any kind of infringement and disputes against the actual composers.
Wow, I think this is lovely again. Sanjeev ji, tell me one thing, one final question to wind up this wonderful enlightening conversation. Sanjeev ji, I wanted to ask you, like, for example, you were talking about pictures. Now, just in case there is a picture available on the internet, maybe in the free space, and, if I make some changes in it, maybe I change the color combination and I change the words of the picture, we modify it somehow. Is that okay to use that picture? I think in that cases still, do we have any legal complications? Can we expect any legal complications in those cases?
Have to do something. Better is you inspired by the picture, draw the picture or whatever. But even if you do it by whatever, now you have all the apps and all that to redraw and all that. So it should not just, there should be something of your imagination, some flavor of minimum level of flavor of creativity has to be there.
Sure. So great. I think what we are trying to say is that there is a picture on the available in the free space in the internet on the internet, and we try and modify it and then use it or maybe commercialize it. I think it's absolutely all right. Is that what, Pankaj ji, is that right? Can we use that picture after making few changes in it?
Not changes, but I would say substantial changes. Because one thing we must remember, one thing, that there is no copyright of ideas, right? So there are you can always be inspired of the ideas, but whatever picture you are using it, there has to be a substantial change. So once you have a substantial change, you are the copyright owner. So whoever makes a substantial change inspired by one photo or one picture, he becomes the owner of the copyright.
All right, lovely. I think this was a wonderful and a very, very enlightening dialogue with Sanjeev ji and Pankaj ji. I think most of our viewers will love it. And this has been a great, insightful information that you have shared with all of us out here. I'm sure the viewers are going to make very good use of it. This is the need of the hour. We are into blogging. We are doing many things these days, but it is important to safeguard our legal interest. Thank you so much, Sanjeev ji. Thank you so much, Pankaj ji, for coming on board and sharing this important information for people who do not know what they are entering into, what they are heading for. I think this is very relevant topic that we have discussed today. Thanks a lot for coming on board, both of you. Thanks a lot. Thanks a lot, sir. Thank you. Thank you so much. Have a great day.
Thank you.
Very apt information being shared by Sanjeev and Pankaj, and very relevant for today's time because the entire world is busy on the internet today, blogging, making WhatsApp content, making content for their YouTube channels, making mobile apps, writing blogs on LinkedIn, on Twitter, on Facebook. We are making so much of content the entire day. The pictures we are using, the music we are using, we need to be very careful. We are using these things to enhance the content of our blogs or maybe our YouTube. But it is important to keep in mind the disclaimers, the copyrights, the trademarks, the licensing part of it. These things have to be very well in control of you because you are the owner, you are the author of the content that you have put on the social media handle. Now, how you bring that content together is also your responsibility. So please make sure you keep these things in mind because this can land you into trouble if not handled the right way. So continue making good content for social media handles and make sure you keep your legal interests safeguarded. Wish you all the best. Stay tuned for more.